Excuse me, could I have? Thank you very much.
Thank you.
So your Lordships are asking about Article 4.2
Yes.
of the regulation and the meaning of "and which is binding on the relevant court."
Yes.
We respectfully submit that the explanatory memorandum is of assistance in understanding what the legislators were meaning. I've got some authority if you need on why explanatory memoranda for UK legislation is admissible, but I think Benyon accepts that. So, my Lords, the relevant paragraphs of that are 2.6. Your Lordships may recall the issue was whether or not the ability to overrule EU case law should be confined to the Supreme Court, or whether it should be extended to either the Court of Appeal or the High Court. That was the consultation which took place.
Mm-hmm.
And the upshot was that they decided that it should be extended to the Court of Appeal in order to prevent delay in everything having to go to the Supreme Court to be determined. But in doing so, they also explained what they meant by any alteration to precedent, and we can see that in 2.10 and 2.11.
Yes.
Normal operation of precedent between decisions of UK courts, and we get it also in 6.5. So they're not intending to amend the existing operation of the doctrine of precedent between decisions of UK courts in any way. Paragraph 6.5
Yes.
And 7.6, they say much the same thing. The instrument also clarifies the doctrine of precedent will apply in the normal way. And then they go on to say the last sentence of 7.6, the instrument does not allow these courts to depart from retained domestic case law, which relates to retained EU case law in circumstances where they would not otherwise be able to. So it's pointing out that so our interpretation of the end part of regulation 4.2 is to say, and you can't go further than you could have done previously. It's not saying, in fact, the rules of precedent are now more binding than they were.
No.
It's just it's confirming for the avoidance of doubt that the rules of precedent are the same as previously applied. And then you get the results of the consultation are referred to at 10.15 and 10.16, and they say in 10.15 there was a strong consensus that there was no justifiable reason to depart from the normal operation of the doctrine of precedent. And that's why they come to the, and they give the reasons why that would be. It would interrupt legal certainty and predictability if the doctrine of precedent was amended.
Yes.
So, my Lords, in our respectful submission, all regulation 4.2 does is to confirm that the doctrine of precedent that has previously applied in this court still applies, and there's no special rule, no gap for the courts to avoid the normal rules of precedent, notwithstanding the impact of these regulations.
That is to say, we are bound by our previous decisions, except where Young and Bristol Aeroplanes applies.
You're bound by the ratio of your previous decisions. Yes, yes. And we say, with respect, that you are neither bound by the ratio. There's no ratio in neuron which binds you, and even if you did consider you were bound, it is in fact per incuriam, and so it does fall within one of the exceptions in Young and Bristol's Aeroplane, because the points were just not argued in the way that they're being argued today. And if I can very briefly just explain why, first of all, the ratio of the case is not relevant to the present case. So we're back in Authorities tab 19. And as we we discussed before lunch, this was about the definition of product and whether product was sulfonamide only or sulfonamide plus L-DOPA, etc. And my Lord Justice Birss summarised the EU case law first in paragraph 20, and you refer to the case law on product in paragraph 20, and you refer to Pharmacia, MIT, and YISM, as we have discussed, and you say that that is, they show that there is a narrow definition of product, and we agree. Then you were referred to Neurim, and you were referred to Neurim for the point that you should be more teleological and should therefore give more weight to purpose than Pharmacia or MIT or YISM suggests. And you note at the bottom, well, you note halfway through the paragraph, you say that judgment proposes that contrary to the early CJU cases, the use to which a product is put should be taken into account. And as I've submitted this morning, we say that's not in fact what that judgment properly understood does suggest. It doesn't diverge from the strict interpretation of product under 1B. And then you also noted at the end of the paragraph, nevertheless, a notable aspect of the CJU's judgment in Neurim was that while it appeared to reverse the earlier three cases, it did not refer to them. And again, I've addressed that this morning. Then you refer to Santen and summarise that. And then you come on in paragraph 28 to deal with the arguments put before you. And the basis for the argument put before you was the Advocate General in Medeva, but it was the Advocate General's observations in relation to Article 3B in Medeva that were being relied on, and particularly the answer to question 6, where she suggested and the court agreed that you could get multiple patents, multiple SPCs for the same product. And you then summarise the argument in 29 that a broad or teleological approach to Article 3B should be taken, and you reject that, and you say in 30, Medeva doesn't alter the law as I found it to be looking at the run of CJ authority up to Santen. It's a broader outcome-driven teleological approach in Neurim itself which led to the difficulty, in that case, making it inconsistent with the run of previous authority, and I've addressed you on that this morning. And then you say Santen concludes that the right approach to interpreting the SPC regulation in the present context, you say that's important, is a strict one when one is examining what counts as the product. That was your ratio, and we say we don't disagree with that. There's nothing I've submitted to your lordships this morning, my respectful submission, which...
It goes on in paragraph 32 to apply that to the interpretation of the marketing authorisation. And of course, I accept your point that the context is Article 3B, but as we were discussing this morning, that feeds through into Article 3D, doesn't it?
Well, it doesn't on the facts of this case. The facts in this case were what was the active ingredient in the marketing authorisation? And although it referred at one point, the SMPC referred at one point to levodopa, the active ingredient was sulfonamide. And that was, and applying a strict approach to the definition of product, your lordships, in my respectful submission, correctly determined that the case law on strict definition of product applied, and on the facts of that case, it was said that sulfonamide was the only active ingredient. And for those reasons, you came to the decision you did. And my lords, we don't criticise that, and we don't say that anything that your lordships found in that case was inconsistent, and to the extent it was inconsistent, it was either because the arguments were different, or because it wasn't suggested to you that even if Santen, in your words, restored the orthodoxy, it could still be ignored because this court was being invited to depart from the CJU case law in the way it's now allowed to do. So, my lords, for those reasons, we say that it's not binding. It was overturn, not ratio. And even if it's not, it's per incuriam, and nothing in the regulations means that you shouldn't deal with it in the normal way that you deal with precedent. And so for all those reasons, we say it cannot determine the appeal before you today. My lords, yes.
What you just
said to us, it is critical to your argument on the way you're putting your case, that your case is limited to second use, isn't it? Because if your argument means that other things as well as second uses are to be applied, or to be dealt with in the same way as neuron, then this would be bang on the point.
I'm not sure it would, my lord. I can see that if I was standing here arguing that formulation patents should also be included under 3D, I'm not sure that my submissions would be any different to you about what you decided in neuron.
Well, what I'm just reacting to what you said. I'm just thinking about it. This is another one of those cases. The facts of neuron, as you're quite right, of course, it's not a second use case, but it's a case in which there are other things as well as the original active ingredient being involved, as it were, putting it very loosely.
Yes.
And what's one of the, you say you don't go that far because you're restricted to second medical use.
Yes, and a single active ingredient, and there's no dispute about what the MA is for, either in terms of indications, or what the active ingredient is in the MA.
Yeah.
And so you were dealing with a different problem in the case before you there, which is why I say that even if I was to go for a broader approach to Article 3D, I'm not sure. I'm grateful. So, my lords, the final point I wanted to show your lordships, and we can do this very briefly, is just to underline the facts of the case, and I can do this very briefly by reference to a document that was before the examiner. So if I can take you in the supplemental bundle at tab 2, to page 100. And this was a summary of the work that went on to obtain the marketing authorisation that's now relied on. And your lordships can see that paragraph 3, the patent was applied for in 2005. Then between 2005 and 2009, 3 pivotal clinical trials were performed. That was filed in 2009. This is the following paragraph, but that was rejected in 2010 on the basis of safety. So the fact that this product had previously been approved for hairy cell leukemia did not mean that it could automatically be assumed it was safe, because in fact the regulators rejected the application for marketing authorization based on safety results in 2011. And that resulted in a significant amount of additional work to apply for a further MA following many patients with 10 years follow-up, and a further MA was applied for in just below the bottom hole punch in 2016. And even that, the client, Merck, met some difficulties, and they were only allowed and given an authorization on the promise that they would carry out additional ongoing studies with patients over a period of 10 years, and that's the last paragraph on the page. So this really was a labour of love for Merck Serono to get this product approved, and there was very considerable delay because of no doubt legitimate concerns by the regulatory authorities to make sure that the product was both safe and effective. So this is absolutely the sort of case which is deserving of protection under the regulation and in accordance with the explanatory memorandum. And we emphasise all the facts point towards this being a completely different use to the previous use previously authorised in 1995 for hairy cell leukemia. There was no earlier SPC for the hairy cell leukemia. That product was owned by a different party. At the time that the work was done to obtain the second authorisation in this case, the law was the law according to Neurin. And whilst I'm not seeking to revive the legitimate expectation argument run before the court below, plainly the availability of an SPC was a relevant factor in Merck Serono agreeing to carry on with this very difficult and
Where's the evidence from your client that says we only did this because we thought we could get an SPC?
As I say, there was evidence before. It's referred to in paragraph 45 of the judgment below. I accept there is no evidence formally before the court, and I'm not saying on instruction that it's the only reason that these clinical trials were taken or carried on, but it was a part of the reason. And so the work that was carried out in our submission is entirely consistent with the aims of the regulation to encourage this sort of work, and without the benefit of SPCs being allowed for this sort of work, we submit that valuable second medical use drugs such as finasteride, sildenafil, the BCG product, these sorts of drugs may well not come to market if SPCs are not available. And so they are more important, even more important than they were when the SPC regulation was entered into.
Really can't let that go. You cannot
sorry.
possibly be standing there telling me that sildenafil wouldn't have come on the market without SPC protection.
Well, it was a second medical use drug. I don't know I was giving examples of valuable second medical use drugs, my lord, and that's all. I'm just saying that they are well known in the field, and they're no doubt developing more because of the absence of smaller molecule products. So, my lord, we say it's all consistent with the regulation and the objectives behind it, and that's why, in the end, we say the decision of Neurim should be preferred to the decision of Santen, because the Neurim decision does give effect to the objectives of the regulation. The Santen decision only looks at the literal words of the regulation and ignores its aims and objectives. And for all those reasons, my lord, we say you should allow this appeal, unless I can help you any further.
Thank you very much. Yes, Mr. Stewart.
My lord, Merck's position on this appeal is to invite you to adopt a teleological interpretation of the SPC regulation that allows for SPCs for second medical uses. In doing so, they ask you to depart from Santen. The justification for the teleological approach is that owners of patents for second medical uses are just as deserving of the additional compensation provided for by SPCs, as they too have spent time and money in conducting clinical trials. Our position is that now we understand their position as to exactly what it is you are being asked, exactly how it is that you are being asked to adopt the regulation. We say that firstly you can't, because the approach that they're asking you to adopt requires you to depart from Neuron, which you're bound by, and also requires you to depart from Santen, which we say you can't do because you've applied Santen in Neuron, pursuant to paragraph 4.2. And I'll come on of the 2020 regulations, and I'll come on to those two factors in due course. But just for a bit of clarification as to our overall position, we say that the very basis for which it is said that the teleological approach should be adopted, i.e. that SPCs should be available for second medical uses, is already provided for to the extent thought appropriate by the legislators. And although the SPC regulation is an EU instrument, it is now retained or assimilated EU case law. It has not been materially changed since Brexit. And this is not a case where it can be said that there is no rational basis for the regulation to have been drafted in the way that it was, nor for Parliament to have chosen to reenact the SPC system without any material changes. In short, it's not unfit for purpose or an otherwise irrational, or otherwise presents an irrational position. The objectives of the SPC regulation include ensuring sufficient protection to encourage pharmaceutical research, to create a uniform solution at EU level by creating an SPC which may be obtained under the same conditions in each member state, to take into account all the interests at stake, including those of public health, and to provide a simple and straightforward and transparent system based on objective criteria that can be easily applied and doesn't lead to excessive bureaucracy. And we say it's important that the SPC system seeks to strike a balance between those various interests, and that very balance is struck in terms of the regulation itself. It's not a balancing exercise which the courts are being undertaken, or those bodies granting SPCs are being asked to undertake on a case-by-case basis. And in this context, we say it's worth keeping in mind that patent protection for second medical uses has been available since late 1984, following the enlarged Board of Appeal decision G583. And second medical use claims and patents were therefore firmly established prior to the explanatory memorandum and, of course, the SPC regulation itself. So there's no basis to believe that the possibility of certificates for second medical uses was not something that should be fully accounted for in the balance of interests at the very heart of the regulation. On the contrary, the regulation does provide for SPCs for second medical use patents in certain circumstances. The SPC regulation does not contemplate granting additional SPCs for medicinal products, i.e. products that have been authorised to be on the market. Hence, only one certificate may be granted for any one product. That's Article 3C. And whilst the SPC regulation does allow SPCs to be granted for new applications of an old product, such as second medical uses, these must rely on the first granted marketing authorisation for the product. That's Article 3D. Further, a granted certificate will, within the limits of the basic patent, protect for any use of the product as an authorised medicinal product that has been authorised. And we see that that's the balance that's set by Article 4. So the legislators have therefore clearly considered how to deal with these new uses and have set the boundaries through the legislation accordingly. So to take that in a bit more detail, if we pick up the regulation, which is tab 22 of the authorities, we can see in Article 1, we have there the definitions of medicinal product and basic patents. And we can see in Article 3 that at 3A, this is a substantive conditions for registration, and at Article 3A, the product must be protected by a basic patent in force. 3B, a marketing authorisation must have been granted to permit the product to be placed on the market as a medicinal product. 3C, the product must not have been the subject of a previous certificate. And 3D, the MA in 3B must be the first MA to place that product on the market as a medicinal product. So pausing there, if I had a second medical use patent for product X with a treatment of, say, anemia, thus satisfying Article 3A, and I also had an MA for product X indicated for anemia, thus satisfying 3B, then providing that product X had not already been the subject of an SPC, satisfying 3C, and my marketing authorisation for product X for anemia is the first MA granted for the use of X as a medicinal product, then I can get my SPC. That fact that my patent is a second medical use patent is not in and of itself an impediment to getting protection by way of an SPC. And finally, in Article 4...
So you're postulating, are you, patent 1 claims a product for a particular use.
Correct.
Patent 2 claims the same product but for a different use. And product 1 never had a marketing authorization.
Correct.
It must be quite rare, mustn't it?
Or it may have not even had a patent. It's not a requirement that the product is an old product in the sense of it's previously been the subject of a patent. A product may have gone through some provisional testing but never made it through to a sufficient stage that warranted either patent protection or a marketing authorization. Those situations do exist. So Mirabegron was an example of a case in which the drug was known, it had been hypothesized as use for a treatment for diabetes. In fact, ultimately, at a fairly early stage, it was unsuccessful and no marketing authorization was obtained. A second patent exists, which was confined to the use of mirabegron for the treatment of OAB. That was granted an MA and an SPC, but it was ostensibly, in patent terms, it was a second medical use patent because the product was known, even though the product had never been the subject of a previous patent or SPC. And Article 4, this provides that within the limits of the protection conferred by the basic patent, so that's a reference to 3A, the SPC shall extend only to the products covered by the marketing authorizations to place the corresponding medicinal product on the market. That's 3B and 3D. And this is the important bit, and that's for any use of the product that's been authorized before the expiry of the certificate. So in this scenario, I have my patent, 3A, I have my marketing authorization, which initially was just for anemia, that would be 3B. The product X, has not previously been the subject of a certificate, that's 3C. And as far as 3D is concerned, this is the first marketing authorization that exists for my product X. It was originally granted for, say, anemia. Pursuant to type 2 variations, additional indications and what have you can be added. They're all contained within the scope of that existing SPC. So that SPC can cover the additional indications, but what you can't have is a separate new SPC for those indications. That is the framework of the SPC regulation as it stands within the confines of the language there. So there's nothing about the language per se that prevents SPCs for second medical uses unless a marketing authorization, apart from circumstances where the marketing authorization has already been granted. So in circumstances where a marketing authorization has already been granted for that product. So we say that this isn't
So if we just track back a moment through the definitions.
Yeah.
We've got definitions of medicinal product and product.
Yeah.
And Mr. Mitchison accepts, I think, that product has to be narrowly interpreted because that's what the CJEU says. So it's all going to turn on what is meant by a medicinal product and what is meant by the authorization. And I think if I've understood correctly, you say that any substance which is presented for treating or preventing disease in humans or animals is a medicinal product.
Yeah.
The authorization authorizes that medicinal product for particular uses which are specified in the authorization. And if somebody comes along with a different use for that medicinal product, it fails 3D because it's not the first authorization to place the product on the market as a medicinal product. Right. It doesn't matter that applicant 2 is asking for an authorization for a different use. There is already a market authorization in force for that product in its capacity as a medicinal product, that is to say, as a combination, etc., presented for treating or preventing disease.
Correct. That's what we say.
Yeah.
And in fact,
that's fairly straightforward as a matter of interpretation of the regulation.
Where we were struggling with a little bit is in how it is that the appellant seeks to interpret Article 3D in order to give the result that the appellant wants. And initially, it seemed to depend exclusively on an interpretation of Article 3D. And that was important because that was the basis on which the appellant is able to sidestep cases which it says are considering Article 3B or Article 1B. But in fact, I think it's a little bit more complicated than that, as we established this morning, in that I think what the appellant has to do is to say that Article 1A, the product is protected by a basic patent in force. The product there, so did I say 1A? Sorry, 3A. The product there is the narrow definition of product from Article 1B. So that doesn't provide any difficulties. But then what we have is the valid authorization to place the product on the market as a medicinal product. And I think we now have to insert the words for the patented use has been granted in accordance with directive. The product has not already been the subject of a certificate, and I'm not entirely sure at the moment whether that product is the narrow product of Article 1B or is the product for the patented use of the medicinal product in B. And as far as D is concerned, the authorization referred to in point A, in point B, is the first authorization to place.
My understanding is that Mr. Richardson doesn't contest that the product which is referred to in all of A, B, C and D must be the same. It must be the product as defined in Article 1B, and he accepts the narrow interpretation of the definition of product. And so therefore, the argument is all about, as I understand it, the word authorization, and the argument is you read in authorization as referred to within the scope of the basic patent, and I think he accepted that you need to read that in both in 3D and in 3B.
Yeah, but in either way, the fact is, whichever way you skin the cat, I don't think you can avoid focusing on 3D in isolation. You also, whatever the change that you make into 3D has to be somehow incorporated into 3B, other thing, where otherwise the whole thing falls apart.
I think he accepted that. As I said, you have to read in within the scope of the basic patent.
But then we say the problem with that is that the teleological approach that you're being asked to adopt is not purely restricted to 3D. It's actually an approach. It's actually an interpretation of Article 3 in its entirety, and that then we say places the appellant in immediate difficulties because one, it can no longer distinguish itself from this court's decision in Neuron, and it is therefore bound by the decision in Neuron, which itself applies Santen. And perhaps more problematically, the fact that this court has applied Santen in the context of Article 3 means that this court can no longer depart from Santen under the Article 4 of the 2000, Article 4.2 of the 2020 regulations. So perhaps I should pick that up here. So I think that perhaps at this stage, the easiest thing is to go back to Neuron and to see what was being held and decided in Neuron. And then I can explain why I say that this causes a huge problem for the appellant. So Neuron is in tab 16.
19, I think.
Oh, sorry.
Someone go back to new rim. I think you want new wrong.
The one I'm looking for is definitely at tab 19. So, sorry, tab 19. Paragraph 1, and it opens with that the question in this appeal is about the meaning of the term product in Article 3B of the regulation, and specifically whether or not the product that was the subject of the MA as required by 3B was the same as the product that was protected by the patent as required by Article 3A. And we can see that in paragraph 3. at 13 of the decision, the court identifies the relevant provisions of the SPC, Articles 1 and Articles 3. And at paragraph 15, the court says we can see what a product is. It's defined by Article B. Following this, one can apply Article 3, noting that the concept which links the four criteria in that article together is the product. And at 16, it's manifest that in the meaning of product cannot be different in these various limbs of Article 3, and before us, Neuron did not contend otherwise. And the court goes on to consider the relevant law at 19, and we can see at paragraph 20, consideration of the earlier decisions of Pharmacia, MIT and Lewison collectively make it clear that product is to be construed narrowly and limited to the active ingredient, etc., that we're all familiar with. At paragraph 21, Neurim, contrary to Pharmacia, MIT and Lewison, proposed that the use to which a product is put should be taken into account, but was less clear how the regulation was to be interpreted to that effect, and specifically whether or not it was reversing Pharmacia, MIT and Lewison, generally unsatisfactory. Then at 22, move away from the teleological approach of Neurim and back to the orthodoxy restored by Santen, and acknowledges there that Santen, of course, expressly overruled Neurim, as we saw this morning, reverting to a narrow definition of the product that excluded use. And so what we're seeing here is that this court is following Santen and in its overruling of Neurim and its rejection of the teleological approach there applied. And we can see at paragraph 33 of the decision that that approach, i.e. rejecting the teleological approach of Neurim and reinstating the orthodoxy created by Santen as to the narrow approach, was a formative basis of the decision. And that was an operative part of the decision leading to the rejection of the first ground of appeal that we see at paragraph 37. And so we say that this is a situation in which this court has interpreted Article 3 and has rejected a teleological interpretation, has followed, and more important, and has followed Santen in the narrow interpretation. Now, we accept that in the context of that particular case, the court was not being asked whether or not a different interpretation should be given to products when combined in the term medicinal product than the term product that we have in Article 3 that is as defined in Article 1B. But we say nonetheless it was interpreting Article 3 and it was rejecting an approach, a teleological approach, as per Neurim.
Well, paragraph 15 is applying the definition in Article 1B, which everybody agrees is narrow, to Articles 3A, 3B, 3C and 3D.
Correct. And we say that there's no, and so we say that as far as that is concerned, the overall approach, the overall consideration of the regulation, the overall consideration of the interpretation of Article 3 of the regulation was expressly before the court in Neuron, and it rejected the teleological approach of Neurim, followed the more limited approach, the orthodox approach that we see in Santen. And we say that that raises two problems for the appellant. And the first is how does, the first is we say that you're bound by Neuron in terms of the application of Santen, and in the absence of any request by the appellant that you depart from the Neuron decision, and none have been put forward this morning, then we say that you are bound under that. There's no basis for departing as a purely matter of domestic law under
Well, is
Young.
that right? Mr. Mitchell makes 2 points, I think. First of all, he says what was said about Santen wasn't ratio. And second, he said even if it was per incuriam.
Well, as to the first, we say that that's not quite right because I've already shown you where the combination, we say, of paragraphs 15, 21, 22, 30 makes it quite clear that the Santen approach to interpretation was very much part of the operative decision which led to the finding in 33 and the consequence in 37.
Yes.
As far as
you light on the phrase applying the law above.
correct.
And that law is Santen.
Yes, and I mean, and in paragraph 30, in my judgment, Medeva does not alter the law as I found it to be, looking at the rung of CJE authority up to Santen. It was a broader outcome-driven teleological approach in Neuron itself, which led to the difficulty in that case, making it inconsistent with the run of previous authority. Santen concludes that the right approach to interpreting the SPC regulation in the present context is a strict one when one is examining what counts as the product. That's clear application of Santen and it's operative to the decision that was made. As to whether or not it was per ancuriam, I don't accept that the decision in Neuron was per ancuriam. As I understand it, the reason it is said to be or have been per ancuriam is because the court hadn't been asked to depart from Santen, hadn't been asked specifically to consider whether or not Santen was a correct decision. But in my view, that's insufficient to decide that the decision was per ancuriam. The fact that somebody else could have or even should have argued it a slightly different way and that may or may not have reached a different decision doesn't render the decision per ancuriam. There has to be, for example, a statute which would have been definitive of the decision but for some reason hadn't have been put forward before the court. Yeah, otherwise every authority can be distinguished on the basis that, well, I would have argued it slightly differently and so would have arise at a different result. For completeness, I would point out that insofar as it matters, that it was part of the controller had raised the possibility that it was open for the court to depart from Santen, given the chronology of events, this being a hearing that took place in January, but it wasn't part of an argument that was being advanced as part of the controller's case, and it wasn't something that was taken up by the appellant during the hearing.
I confess that although we decided it this year, I can't remember any of that.
but the point is that the point having been made that it was open, that the court, at the time that the hearing took place, which I think was January this year, the chronology
yes, 24th
was,
of January, we heard it.
So the controller pointed out that chronology was such that it was open to the Court of Appeal to exercise its powers to depart from Santen, but it wasn't something that the controller was arguing that the court should do, and it wasn't a point that the appellant itself decided to take. But it wasn't as if the point had never been mentioned and wasn't considered.
So you're saying that the power to depart was something to which the court was referred.
Correct.
Yeah, I don't remember that, but I'm sure Dr. Barron's right about that.
Yeah, I mean, and I can produce the skeleton arguments if they needed, but it wasn't something that was argued because it wasn't part of the positive case that was being run by the controller, but the controller did draw attention to the court that those powers existed.
I've got the skeleton still on my computer.
Yeah.
Here it is.
Paragraph 53 and following.
53, yeah. So, I mean, but
52 is can I see it?
But so the only is it wasn't something that no party had raised, but it absolutely wasn't something that either party had argued. But I say that it's that alone, the fact that the parties in that case chose not to argue it, is not a basis for saying that the decision, therefore, itself was per incuriam. So we say that as a matter of domestic precedent, this court is bound by Neuron in any event. We also say that there is the additional hurdle faced by
Christmas drinks.
There's the additional hurdle that's faced by the post-Brexit legislation. And so just stepping back for a moment, Santen is assimilated EU case law within the meaning of Section 6.7 of the European Union Withdrawal Act 2018. You don't need to go there, that is in the authorities at tab 23. And pursuant to Section 6.4a, the Supreme Court was not bound by assimilated EU case law, and pursuant to 6.5 of that Act, in deciding whether or not to depart from assimilated case law, it must apply the same test as it would in deciding whether to depart from its own case law. And if we go back, you can see at 6.4ba that a relevant court is not bound by any assimilated EU law so far as provided for by regulations under Section 5a, which entitles the Minister of the Crown to provide for other courts to be a relevant court. And that's exactly what happened with the snappily titled European Union brackets Withdrawal Act 2000, right? That one that we handed up this afternoon. And what we can see there is that pursuant to 3b, the court was appointed a relevant court.
Yes.
And pursuant to 4a, a relevant court is not bound by any EU case law except as provided for in paragraph 4.2. And 4.2 says that a relevant court is bound so far as there is post-transition case law which modifies or applies that retained EU case law and which is binding on the relevant courts. And as far as that is concerned, we say that one, post-transition case law, that's defined at paragraph 2, any principles laid down by and decisions of a court as they have effect on or after completion day, that was plainly before the decision and the hearing in Neuron. As to 2, we say that plainly Neuron applies Santen. We've just been looking at that, and it does so in the context of Article 3. And we've just been looking at that in the decision in Neuron. And so we say that that is plainly a situation in which this court has applied Santen, and we say that that is actually all that is required for Regulation 4.2. So all that's necessary is that if this court has already modified or applied Santen, and Santen is binding on the relevant court, then this is a reason why you cannot depart from Santen itself. And it's a little bit circular because obviously you can't apply, if you can't depart from Santen, then the appeal doesn't get off the ground in the first place. And so we say that in essence, the appellant faces 2 insurmountable hurdles.
Is that a different hurdle? I just wonder. There seem to be two conditions in order to satisfy 4.2. First is that there is post-transition case law which applies retained EU case law.
Yeah.
That's Neuron. The second is, and that is the case law, Neuron,
Yeah.
is binding on the relevant court, that is us.
Yes.
Now, does that not let in the young and brittle aeroplanes exceptions?
It has to, yeah, but I agree that it has, the fact that it has to be binding on this relevant court means that you have to therefore satisfy the decision. In order for it not to be binding, rather you have
that's
to
a question of
satisfy-
domestic law.
That's a question of domestic law. But we say that, as it happens, you're bound by, as a matter of domestic law, you're bound by Neuron in any event. Neuron also happens to apply Santen, and that means that you can't depart from Santen either. So
Yes.
therefore, there's two, and we say that in order to get home on this appeal, they need you to depart from both Santen and Neuron, and in fact, you can't depart from either.
Yeah. So there are two gates they've got to get through.
Correct.
They've got to persuade us that we should depart from, persuade us we can depart from Neuron on domestic grounds.
Yeah.
And if they get that far, we must then apply the Supreme Court test
Correct.
to decide whether or not to disapply Santen. Is that how you put it?
Correct.
If,
Well, sorry.
sorry, Stuart. I understand your case, your submission is that what I'm going to say isn't your case, isn't this case. What I've been trying to get my head around is whether, what if the state of affairs was that there was a decision which was binding in this court in the sense that it was a previous decision of the Court of Appeal and was not per issue.
Yeah.
And it applied the EU case law, but as it happens, that earlier decision, the ratio of that earlier decision isn't relevant to the question we're having to decide, but what we're being asked to do is apply the EU case law, which that previous decision applied. In other words, I suppose the way of asking the question is, does the binding thing referred to in sub 2 refer to both the position of the decision relative to this court, or does it also include the fact that it's a ratio for the question we have to decide?
Yeah, well, what I would say is that in that scenario, the earlier decision of the Court of Appeal wouldn't be binding because the Court of Appeal would be able to distinguish the earlier decision in coming to its new decision, but for the fact that it had applied the case law. So they are two separate decisions. So let's say, for example, that in fact, the Court of Appeal in Neuron had been looking at Santen, but in the context of something that of no relevance to this case, this particular case, some quirk of, I don't know, Article 16 or something that wasn't of any relevance. In that case, I would have argued that you weren't bound by that because you can distinguish it. So you don't get into the question of domestic precedent at all. And therefore, what this is doing is saying, well, it doesn't matter that Santen was applied because it was applied in a context in which didn't give rise to the fact that it was binding. So in many cases, that although the same issues arise, there are actually two separate impediments.
But if you're not within Regulation 4.2,
yes,
because as a matter of domestic law, the second court is not bound by the first court, you then pass on to Regulation 5 and you apply
correct,
the Supreme Court test.
Correct. And I've got some various bits to say on that. I don't know if you're particularly, they seem relatively minor in the general scheme of things, but we do say that they are points that really haven't been pressed at all by the appellant. The first is we make the rather obvious point that in applying the test, this is a test that should only be applied in limited circumstances. It's intended to be a strict test. I think focus has been placed on whether or not it's the right thing to do, but in essence, the purpose of the test is to protect legal certainty unless it's considered manifestly unjust that be the case, and that's the context in which it's suggested that it should be the right thing to do. I'm aware of two instances where this court has considered, in the context of certainly intellectual property, whether or not the factors are such that it should depart from its previous decisions. And the first of those is tune-in. So looking back, we're now in tab 17. And we can pick it up at paragraph 78. And the point there is that my Lord Justice Arnold is observing that in that case there had been no change in the domestic legislation. That's equivalent to what we have here, in that the assimilated law had been adopted without change, exactly as we have here. At paragraph 79, no change in the international legislative framework, and that is also relevant here, in that the SPC hasn't changed as far as the rest of the EU are concerned, although I think it's fair to accept it's probably of less importance in this particular case because it isn't in the course of a wider set of treaties to which still apply to the United Kingdom post-Brexit. At paragraph 79, we have paragraph 80, that's specific to the interpretation of communication to the public, and suggestion there that that's a difficult task, and simply the fact that the previous decisions and jurisprudence have suggested some various different interpretations isn't a reason. And I think we have here Lord Justice Arnold saying that the CJU has unrivaled experience in confronting this issue in a variety of factual scenarios, and I would beg to say that that is exactly what we have seen this morning. In the CJU has been applying the scope of the SPC regulation in a vast array of particular factual scenarios requiring particular consideration of different facts. The jurisprudence is not free from difficulty or criticism, but it doesn't follow that there are necessarily better solutions to hand. And we pray and aid the fact that the real mischief on which the appellant seems to rely, which is that the regulation doesn't allow for SPCs for second medical uses per se, isn't on its face a good one when one sees that in fact it does, just in limited circumstances that doesn't permit one in this case. And we also pray in aid, and I'll come on to it in more detail if necessary, that the teleological interpretation of the CJEU in Newham has caused particular difficulty in this area in terms of its application going forward. Paragraph 81, there's a reference to academic criticism, but none has been advanced or identified by any party. And again, at 82, it's not particularly relevant. In this case, there's reference to non-EU jurisprudence, but that's unlikely to be of relevance to the SPC regulation. And then we come to 83, legal certainty, and that's a really important factor. As we saw in the decision in Neuron, Santen withstood the orthodoxy. It was Newham that was the outlier, not Santen. And the appellant's approach inherently creates enormous certainty going forward as to how future cases are to be identified. It's not clear what the situation is going to be in terms of the application of Newham, which itself was not on its facts limited to second medical use patents, but in fact was a general interpretation of Articles 3 and D, which allowed the SPC in that case, and has led to quite a lot of confusion and difficulty amongst various regulatory boards going forward, in which they've often come up with competing and conflicting decisions on trying to apply the test post-neuron. And I'm not going to say anything about paragraphs 87 and 88, which very much turn on the facts of that case. We can pick it up again in industrial cleaning, which is on tab 18. And
Yeah, this passage starts at 80.
yeah, so at 80, we have the usual proviso that departure from previous decisions is a power that should be exercised with great caution. And then the relevant considerations that were taken into account or raised in that particular case is set out from paragraph 82. The particular situation in 82 is one of very little weight insofar as it is, we say it's a point in our favour. 83, we say, is also a point in our favour. The specific point from which the appellants urge to depart from was supported by clear analysis in both the decision of the Grand Chamber of the CJEU and was supported by the AG's opinion. As far as 84 is concerned, again, we think that's a point in our favour as Santon restored the orthodoxy, and it was Neurim that was the outlier. And at 86, again, the point comes back to legal certainty, which I've already explained is of particular importance in the present case. And I'll come on to that specifically in the context of Neurim. And at paragraph 88 is a question of whether or not there'll be undue restriction on the development of the law. And we disagree. We say that Santon restores orthodoxy, and just because a claimant doesn't like the outcome, it doesn't prevent the courts from giving effect to the objectives of the SPC regulation. And just finally, to build in a little bit on the point about legal certainty, is that obviously what you've been asked to do is to adopt this teleological approach, depart from Santon and return to Neurim. And returning to Neurim causes quite a lot of trouble and difficulty, particularly on the part of those like the UK IPO who are actually going to be asked in the future to determine future SPC applications on the basis of the CJEU's ruling in Neurim. And if we can have a look at that, it's worth focusing in a little bit more detail in what it is that the CJEU actually held. And we see that at the very end on page 123. And so the actual ruling is in the context of Articles 3 and 4 collectively. And picking it up in paragraph 1, the mere existence of an earlier marketing authorisation obtained from a veterinary medical product does not preclude the grant of a supplementary protection certificate for a different application of the same product for which a marketing authorisation has been granted, provided that the application is within the limits of the protection conferred by the basic patent relied upon for the purposes of the application of the SPC. And at 2, refers to the marketing authorisation of a product which comes within the limits of the protection conferred by the basic patent relied upon for the purposes of the application for the supplementary certificate. And if we go back and have a look at the reasoning that CJEU applied in reaching that reason, you can see that from paragraph 25. In paragraph 25, if a patent protects a therapeutic application of a known active ingredient which has already been marketed as a medicinal product, whether or not protected by an earlier patent, the placement on the market of a new medicinal product commercially exploiting the new therapeutic use of the same active ingredient as protected by the new patent may enable its proprietor to obtain an SPC. And it picks up in such a situation at 26, only the MA of the first medicinal product comprising the product and authorised for a therapeutic use corresponding to that protected by the patent relied upon for the purposes of the application for the SPC may be considered to be the first MA of that product as a medicinal product exploiting that new use within the meaning of Article 3D. And at 27, says the mere existence of an earlier MA obtained for a veterinary medicinal product does not preclude the grant of an SPC for a different application of the same product for which an MA has been granted, providing that the application is within the limits of the protection conferred by the basic patent relied upon. So we make a number of observations about this, which is first, the judgment seems to be introducing the concept of relevant marketing authorisations, and only relevant marketing authorisations should be considered within the meaning of Article 3D. Second, the product within the meaning of Article 3D appears to be a product plus the new use, whereas in 1B, the product is just the product. 3, Neurim imports into Article 3D a requirement that the scope of a later patent be considered. And 4, there's no clear requirement to consider the scope of any earlier patents. We say Neurim is a difficult decision to understand. It's an even harder decision to apply. A number of difficulties with the Neurim decision have already been identified by my Lord Justice Arnold in AstraZeneca and Abraxas by my Lord Justice Birss in Neuron. We also point out that it's not clear whether or not Neurim was limited to a case where the first MA of the product related to veterinary use would not preclude an SPC on a subsequent patent or MA for human use. And so was the issue there the fact that the earlier MA was veterinary use? It wasn't clear on the face of Neurim what the scenario would be in human use. How different must the new application be? Must it relate to a new therapeutic field in the sense of new medicinal specialism, or should different therapeutic applications be interpreted more broadly? And those two questions are not interesting academic points only. They were indeed the very basis on which Santon was referred in the first place. So if Santon is now departed from, those questions, those ambiguities that Neurim left exposed, that are left open, still have to be decided by these courts going forward if we're not to apply Santon and we're to refer to Neurim. Similarly, following Neurim, would an applicant who already had a certificate in respect of a product protected by a basic patent be entitled to a further certificate for a new use of the product for the new use of the product where the new use constitutes a new therapeutic indication which is specifically protected by a new basic patent? That was a question that was referred to by Novartis by the Swedish courts. But again, that was, it seems that was compromised after the decision in Santon, because of course Santon would have determined the outcome of that particular question.
Can you just give us the case reference to that to remind us?
Sorry, C354 of 19.
Thank you.
And we say that many of these problems stem from the fact that following Neurim, the grant of a later patent can change what's regarded as the first MA, depending on the scope of that patent and whether or not the scope encompasses an earlier MA. Specifically, therefore, if an early MA for the same product per se is outside the limits of the protection conferred by the basic patent, then it changes from being the first MA to place the product on the market as a medicinal product, which would preclude the grant of an SPC to an MA, to one which is irrelevant and doesn't. And that means that how the limits of the protection of the patent are to be interpreted become extremely important. There's absolutely no guidance from Neurim as to how that test is to be applied. And this matters with granted patents with claims relating to combinations of more than one therapeutic use, formulation and dosage regimes, and such claims are commonplace. We have the Abraxas judgment, which suggests that SPC should not be granted for new formulations alone, but it's not clear what the status of the Abraxas judgment will be if this court departs from Santen and reinstates Neurim. It's not clear to what extent Neurim is to be limited by subsequent decisions of the CJEU that haven't been referred to here. And other questions: does a later patent defined only as a formulation primarily intended for use in the treatment of a particular disease, with a corresponding MA limited by use and formulation, but stated in the body of a patent to be suitable for another use covered by an earlier MA? Does that give rise to a new SPC because of the new use, not give rise to an SPC because it's just a new formulation, or end up being refused because the earlier use and MA is in some sense covered by the later basic patent? So we say that there are real practical difficulties that will follow if this court reinstates Neurim and departs from Santen. And we say that that in itself is a requirement, that in itself feeds into the interests of legal certainty, which is one of the key factors that this court should take into account when deciding whether or not it should depart, whether or not it satisfied the test of departing from decisions of the Supreme Court. And we say that obviously that is a test, that is a power that should be granted sparingly. A key factor in that is the importance of legal certainty. And on the particular facts of this case, where the legal certainty arising from Neurim is quite considerable, we pray that in aid as a factor why you shouldn't do so in the present case. I'm just being reminded, my lords, that I took you to the CJEU decision in Neurim, where I showed you that the ruling itself was actually related to Articles 3 and 4 and wasn't to a specific provision of Article 3. And that seems to be the difficulty with applying teleological interpretations to parts of the legislation in isolation was one that was acknowledged by the AG in Neurim, paragraph 42. And so you see that she herself picked up the fact that, so bottom of page 109, she says, against the background of that complex situation as regards interests, Regulation 1768 sought to achieve a balanced solution taking account the interests of all the parties. In view of the complexity of that balance of interests, it is necessary to proceed with great caution when making a teleological interpretation of the individual provisions of the regulation. And we would go even further, is that when the teleological interpretation is looking at what the regulation and the regulation in its entirety and the system is intended to achieve, one has to be very cautious, therefore, about trying to apply it to isolated provisions. And indeed, we see there in its ruling that the decision in Neurim applies to Articles 3 and 4 generally, and we're not limited to a particular definition or aspect of Article 3. And I'm told that we now have additional copies of the skeleton argument in Neuron. My lords, unless there's anything else I can assist you
I've just got one question, if I may. Mr. Mitchison told us of this Teva case, which is going to be decided shortly. Is that going to affect anything we have to decide?
We don't think on our side, we don't think it's going to affect anything. If Neurin was to come back in play, then it's possible that the interpretation of the basic patent, which Neurin says might be important but doesn't tell us how, it might be relevant to that. But I don't think it would raise any additional concerns over that point than I've already raised this afternoon.
Thank you very much. Yes, Mr. Smithson, can you reply?
I'm grateful. I'll be as brief as I can. Slightly surprising about my learned friend's submissions is it's basically been based on precedent and not on actually trying to justify the reasoning in Santen over and above the reasoning in Neurin. And she hasn't sought to explain away the UK's approach in Abraxas. And we say that she hasn't really tackled the fundamental problem before your lordships, which what is the objective of the regulation, and has that been met by the interpretation which has been put on the 3D thus far in this case. And she criticises what she says is the teleological approach, as if anything teleological is bad. But the teleological approach is the approach you're meant to use to interpret EU legislation. It's the same as the purposive approach. It's the same as the approach that English courts are meant to take to English legislation. So it's not enough, with the greatest respect, just to say that the teleological approach is wrong and the literal approach is right, because that ignores the fact that we should be using a teleological approach. Now, we can have an argument about what the right teleological approach should be. I do accept that, but merely to wave one's arms and say teleology is wrong, literal is right, is to ignore the basic principle of statutory interpretation to which the European courts and indeed the English courts are used to making. And that's where we say Santen in fact went wrong, and why Neurin and the Court of Appeal in Neurin adopt the better approach. So to take her, she did address you briefly on the policy at the start, and her, my learned friend's submission was that second medical use is already encompassed by the regulation, and she gave you the example of mirabegron and other examples. With respect, we say that is not, that does not meet the objectives of the regulation as expressly set out in the explanatory memorandum. The first example she gave, mirabegron, she said, assume it hadn't been approved, and then there was a later application for an MA and a later patent. In that case, my lords, we say there isn't second medical use, because there's never been a first medical use. The thing has never been approved. There's never been a product falling within the scope of the regulation. And we say that, so that may happen. There may be occasional instances where something never makes it to the market and then a further use is found. But that's not second medical use, the use of a known product as referred to in the explanatory memorandum.
Why not?
Because
I understand, because if it's known, then the only patent you can get is a second medical use, and that's true whether or not there's a first marketing authorisation.
yeah, of course I accept that you can say it is known, my lord, but it's not been known to be a product within the meaning of the regulation. It's not been an active ingredient which is received.
Does it depend on whether there's a first marketing authorisation or not? And if so, how do you get that into your interpretation of Article 3D?
No, I don't say that, but what I'm saying is that the fact that you could get an SPC in the circumstances which she identified, where the first product was never approved, we say doesn't go far enough to meet the objectives of the regulation and the express reference in it to use of an application, new applications of an old product, because it's not really a product if it's never been approved. The other example she gave was if you have a first approval and a first medical use, and then a further indication is found, it would have to be within the lifetime of the SPC to be able to be used. And as my learned friend pointed out, in those circumstances, the SPC regulation suggests that you can have protection for the additional indication as long as it's added before the expiry of the SPC. Now, again, I accept that factual scenario might arise, but it's incredibly unlikely to arise for a number of reasons, and nor is it likely to be of any practical use. Firstly, the second indication has to fall within the scope of the original basic patent, because that's part of the rules. So it would only really be of any use if you had a basic patent which was a product claim and not a first use claim, as I discussed with my Lord Justice Birss this morning. The second problem is that the protection that arises under for that second indication only becomes protection which the owner of the first patent is allowed to exercise. So in those circumstances, someone else would come along, make some new discovery, have that indication, patentable indication, but the protection would become an expansion of the SPC of the original patent owner and not the person who'd done all the work to come up with a second medical use. So that's another reason why it's highly unlikely to be of practical use. So, my lords, although we accept that these two scenarios which she proposed could arise, they're very unlikely to arise. It's very unlikely, in fact, that someone will get their second application and approval through in time before the expiry of the first SPC, and even then there may well be problems with ownership. And what neither of these scenarios actually does is to protect the entity who has started up with an existing product which has been approved for a different use and found a patentable new use, got a patent, then gone through all the steps required to get it approved, finds he or she has only got 5 years left on the patent, and then misses out on the protection which we say the explanatory memorandum expressly recognises should be allowable in those circumstances.
Mr. Mitchison, you mentioned sildenafil. Isn't sildenafil actually an example of one of the things that your opponents mentioned? Because the first indication was never went to grant. The first use of it was angina. The patent was a second medical use patent, and it came on the market with that. So it's exactly the fact pattern.
Well, as I say, my lord, it may be that I'm not saying it never happens, but these are narrow examples, and we don't accept, with the greatest respect, that the ability to get a SPC in these circumstances means that the regulation is doing what it should do according to the explanatory memorandum, because there are.
But can we then be clear as to the relevance of the argument? Because as I understand it, your argument comes to this: you accept that under the regulation as interpreted by the Comptroller, SPCs for second medical use patents are available in some limited circumstances.
Yes, my lord.
But what you say is that the justification of incentivising new pharmaceutical research extends more broadly than that. And I can quite understand that submission, but the difficulty at the moment I see with it is that if that's the driving imperative for interpretation, why do we stop at second medical uses? Because that's true of all patentable inventions in the pharmaceutical and biotech arena. So the same purpose would justify protecting new formulations and so on.
Well, my lord, I accept that as a general point of principle, of course. But all I need to do today is to explain why we say that the explanatory memorandum justifies a finding, we call it the Neuron exception, to allow SPCs to be granted for second medical uses. And I'm addressing my learned friend's submissions. We say that properly understood, paragraph 29 of the explanatory memorandum, which is talking about new applications of new or known products, is talking more broadly than the two limited examples which she gave. And so to say, the regulation does what it says it's going to do by allowing you protection in the circumstances which my learned friend came up explained today, doesn't, we say, meet the explanatory memorandum. If I was arguing here today about formulations, I accept I'd have a more difficult, I'd still be relying on the principle, but I'd have a much more difficult job finding the bit of the explanatory memorandum that supports that argument. So, and I don't need to go that far today. As I say, that's for another day. But as far as merely further uses of known products, proper second medical use, not second medical use in the patent-only sense, which might never have contemplated a first use. All it's really contemplating is a first disclosure. It's second medical use in the genuine sense of it is the second time it is being used as a medicine. And that, we say, with the greatest respect, is not allowable under my learned friend's interpretation of the regulation, but we say the explanatory memorandum does contemplate it. So that's why we say Neuron is right. Then my learned friend turned to Neuron, and I think your lordships have my points on that. You were asked to decide, make a decision about an argument about the meaning of product in Article 3B. You weren't asked to arrive at a judgment, deliver a judgment which deals with the meaning of authorization in either 3B or 3D. And that's one of the reasons we say Neuron doesn't apply. You were also being asked to apply the body of CJ EU law as a whole on the meaning of product. We are asking you today to just make a decision about the meaning of authorization. And we're not asking you to apply CJEU law as a whole. We're asking you to depart from the latest binding decision in the CJEU Santen and in fact go back to Neuron. So we are asking in two material respects the court to do something very different in this case to what the court was asked to do in Neuron. And we say that for those reasons, the decision in Neuron just doesn't apply either on a conventional basis or given the way that the case was argued before you and you weren't asked to apply the Supreme Court or House of Lords practice direction to depart from Court of Justice law. So, my lords, that's what I say on Neuron. Finally, my learned friend came to the test under the practice direction. We accept the principles that are well-established principles that apply to it. It is to be applied sparingly. We accept that. But we do say that all the circumstances of the present case make it a suitable case in which to apply that exception. My learned friend took some time to submit to you that Neuron was difficult or had caused legal uncertainty. And I'm afraid we just don't accept that. We accept that Neuron was perhaps a surprising decision for some people who had thought that the law was otherwise, but it doesn't mean it's a difficult decision to apply. There's no suggestion that the Patent Office cannot tell what a second medical use patent is and determine the scope of the claims and whether or not...
How do you explain all the subsequent diverging case law across Europe, of which there were multiple examples, and the multiple subsequent references to the Court of Justice asking for clarification, and the pages and pages you will find in the Max Planck study if you care to look at it?
Indeed, my lord. That was because people wanted to know where Neuron stopped. Neuron is, as my learned friend took you to, it's expressed in very narrow terms. It is expressed in fact, the order does refer to the veterinary use, but in fact paragraph 25 says it can be either veterinary or medicinal. So we say that in fact the judgment was clear that it didn't matter whether the previous authorization was for medicinal or veterinary. But other than that, it is a very narrow order. And what the later references sought to apply the Neuron principle to formulations, to dosage regimens, to different types of patents. And that is where the Court of Justice pulled stumps in Abraxas and said, no, Neuron is the limit. There is justification for a Neuron exception, but it goes no further. And so we say that the uncertainty was caused by people seeing if they could get Nurim to apply more widely. And that has been answered in Abraxas, and we're not asking this court to go behind Abraxas. So there is no difficulty in seeing what the scope of Nurim is. It was answered in narrow terms, which we say it would apply in the present case once you understand that they weren't seeking to draw a distinction between veterinary and medicinal. And the suggestion that there are problems with it is just not supported by evidence or any real suggestion that there would be difficulty applying it. And merely saying, oh, restored the orthodoxy, Santen restored the orthodoxy, somehow suggesting that Santen was right and Nurim was wrong, we say only arises if the analysis hasn't been carried out to understand precisely what the previous cases, MIT, Pharmacia, Yissum, decided, and why Nurim in fact doesn't depart from those cases, and why neither Nurim nor, in this case, are we suggesting that the court needs to depart from the strict definition of product, which has been established in a number of cases. And if that's the only orthodoxy, it's the strict definition of product, and we're not suggesting that your lordships need to disturb that in your lordship's judgment today, and that's why we say Nurim doesn't in fact cause practical difficulties, nor does it actually disturb the waters in a way that my learned friend had suggested to your lordships earlier. My learned friend referred to the Novartis case. We haven't got it before us, but it may well be that case was withdrawn once the Santen case had been delivered. That's, of course, because the Swedish courts are still bound by the Court of Justice decisions, and so once that decision had been handed down, there was no point in pursuing it. The reason why we are different now is because of Brexit, because I am entitled to stand up here and ask your lordships to ignore Santen and revert to the sensible approach adopted in Nurim, which we say, for all the reasons I've been over, we say you should do. And so, in short, we say my learned friends resorted to in terroram suggestion that, oh, there's going to be a whole slew of cases and uncertainties arising if your lordships accede to my appeal today. We say not so, no evidence of that, no real basis for her suggesting that. Very limited number of SPC cases in the UK as a whole. And all that adopting Nurim would do would be to benefit a limited number of applicants who have undertaken the work to come up with a separate and different second medical use, which we say is deserving of protection for all the reasons that I went through this morning. Final point, just a small point on Lord Justice Arnold asked me about the overlapping courts, or pointed out the overlapping courts in Abraxas and Santen, and the point about whether or not judges were aware of the UK submissions. Lordships, of course, right, there were overlapping judges, but in fact the number of overlapping judges, I think it was only 3, far outnumbered by the new judges. So for all we know, they might all have been saying, oh, no, the UK is right and Nurim's right, but they were all outvoted. And we just don't know. So there, I'm afraid, just on the numbers, there's very limited inference one can take from the fact that there were some people who were present on both the...
Numerically, you're of course correct. But what do you say to the fact that the rapporteur was the same in both cases?
I have no idea what role the rapporteur played in the 2 cases, my lord. I would be speculating. We know it's different. Advocate General.
We know what the rapporteur's function is. The rapporteur's function is to draw up the report for hearing, which is of course no longer published as it used to be, setting out the arguments, and then to have carriage of the drafting of the judgment.
Yes. Well, if we were able to, as you say, if we had access to the rapporteur's report, that might be of some help to see how things were decided. We don't, I'm afraid. So, there we go. Can I just check if there's anything else?
Only if you want to say something on the issue that the eligibility.
One final point. I was asked this morning about balance and about balance and how the regulation balances the various rights. And I should have pointed out that, of course, the main way that balance is achieved is through the term of the SPC and the limit in the term of the SPC and the limit to both the scope of the patent and the marketing authorization. So there are numerous ways in which the regulation is balanced. And as, of course, the Court of Justice pointed out in AHP, the primary desire for the legislation is to encourage more pharmaceutical research. There are other considerations which come in, which I accepted this morning, and some of the ways they come in is by restricting the scope of the SPC and its term. So we say overall the encouragement and the desire to promote pharmaceutical research would be best met by the grant of an SPC in circumstances such as the present.
Just one question. As I understand it, the patent expires next week.
I thought it was 2025.
It's 2025.
December
2025. Fine. Well, you'll get the judgment.
Yes, yes, yes. I think the patent expires in December 2025, and the SPC would.
I was just worried it was a week's time.
Right, well, thank you very much for your interesting arguments. We'll go away and think about it. You will get a draft judgment in due course. Don't expect it as a Christmas present. It'll be your opportunity to correct any typos and grammatical errors, but not to correct our reasoning or to introduce new arguments. We would hope in the light of the draft you will be able to agree an order disposing of the appeal. If you can't agree an order, then please make written submissions, short written submissions. We will make the order that we think appropriate. The hand down will be remote, so there's no need for further attendance. And until such time as a judgment is formally handed down, the embargo, which appears prominently on the draft, remains in force. Thank you very much.
All rise in favour.